to call the meeting to order. We'll do roll call.
Brad Phillips, inspector member. Stephen Reinhardt, inspector member.
Lee Warren, inspector members.
Doyle Williamson, inspector member.
Tony Slagle, Government Affairs.
Jennifer Wheeler, Education Manager.
She's correct. Okay, that's great. That's fine.
Michael Malloy, statutory.
Kristen Warman, Deputy General Counsel.
We're missing Matt Carr, who said that he was unable to make it.
And Sean Emmerich's on the phone, correct?
Yes, inspector member.
Okay. Commissioner Arriaga, are you on the phone? Okay. Commissioner Arriaga was, Avis had asked him to call in to be the Trek liaison for the committee.
Is he permanently the Trek liaison?
I don't know the answer to that, but he is for this meeting.
Who was that?
Commissioner Arriaga.
All right.
And then if I could just say, because we're having some construction, I don't know where it is in the building, but it's very loud. If when people speak, it's just so people on the phone can hear, and also so we can get a clear message. If you could please speak up when you do so. Thank you.
Okay, so I want to
Tony, this is Barbara Evans. I'm online, public member.
Great. Good morning, Dr. Evans.
Dr. Evans?
Morning.
Anybody else on the phone or on the call in? Tony, is this being, we're not online?
No, I was going to mention that during the AMS thing, but I can talk about it now. There was an issue. We're still working out the details of trying to get it. We are trying to move towards streaming the meeting. It's just there's some bumps in the road, if you will.
Oh, okay.
So.
All right, so, agenda item 2, ratification of the minutes of the October 9th, 2017 meeting. Was everybody able to go through the minutes? Is there any changes or? Right.
And just for purposes of the record, we have a lot of members of the public here in the audience with us today. If you would make sure that you've signed in on the meeting roster so we can capture that for our record.
Also, we're not doing your credit for this one for February, correct? And that's already out.
So would someone like to make a motion to approve the meeting minutes?
Okay.
So moved.
Second.
All in favor?
Aye.
Barbara, can you hear me?
Aye.
Okay.
Yes,
Okay.
clearly.
Thank you. All right, and so, yeah, Kristen,
We can go ahead and do
Okay.
this one.
okay, so on agenda item 3, general comments from visitors that are on non-agenda items. Is there anybody that has any comments about non-agenda items? All right. And has everybody turned in their public meeting comment card if you'd like to speak? Okay, so before we go into agenda item 4, reports for subcommittees, General Counsel has asked that we do a
Brief executive session.
sorry, a brief executive session, which means that it's going to be committee members only. And then, so I'd like to adjourn to an executive session, please.
So anyone who is on the call who is not a committee member needs to hang up, please. And then you can redial in. I'll post some comments on the instructions when you can dial in when we're done with the executive committee.
How about if we just adjourn the committee members to another room?
Okay.
And then
Call the other committee
yes,
members.
we'll
Okay.
call those committee members.
Okay, we'll do that. We're gonna put this on hold for a moment, and then we will call the committee members from another room.
Okay, so I'd like to close executive session and reconvene the meeting. And we will start with agenda item 4.
Get the time.
Oh, I'm sorry, the time is 10:26. And we will start with agenda item 4, which is reports from the subcommittees.
subcommittee.
Subcommittee's you guys, I'm sorry. No, I was confusing me already.
Standards of
Standards of practice met this morning.
Standards of practice met this morning. We had really good feedback from both the subcommittee as well as the participants from the community. 2 items of the 4 discussion points came up. We had to table item number 4. Actually, 5 we kind of covered to.
They don't know what item number 4.
Okay, I'm gonna hold on. So we did discuss issues regarding the term deficient or deficiency and possible changes to that term used to describe the defects that we find in home inspections. We kind of came to the conclusion that there's going to be no change on that at this point. It may be up for future discussion later, but at this point, there may not be a good solution to what we have based on our discussion. Item number 3 was discussion regarding possible changes in standards of practice, including A, eliminating outdated or unnecessary items, and B, adding new items. And there was a lot of great feedback on that to consider that worthy of consideration, and probably something that we need to look deeper into.
And then what about the discussion about changes about the inspection report form? Get any on that?
Didn't get to that point. We'll table that until the next meeting.
Oh, okay. All right, enforcement, was there?
Enforcement did not meet.
Okay. And then education.
Also.
I think that's all of you. Okay, so, sorry about the confusion. So, agenda item 5, staff reports from administration and management services, standards and enforcement, and education and licensing.
Just a couple of really housekeeping items to make y'all aware of. As I think we may have mentioned at the last committee meeting, the agency as a whole will be going through sunset review starting this year. We expect the Sunset Commission to come and interview committee members, commission members, and staff, as well as, possibly even take comments from stakeholders. That process we expect to begin sometime in April, and then we expect, as we move through the year, hearings will be held for stakeholders to come and be able to give input. And then, obviously, the Sunset Commission will make a recommendation, and that will move forward in the legislative session for January through May, June of 2019. And then the second item is the commission is beginning the rule review process. And so if there are specific changes to rules that the committee wants to recommend, this is an opportunity for the committee to do that as part of the rule review process, but there's no requirement that the committee do so. I know that the subcommittee, the SOP subcommittee, reported that they were considering, the idea of opening up the SOPs for possible changes, but we expect that to be a lengthy process, so that doesn't have to be done as part of rule review. Rule review is simply a time for the commission as an agency to take a look at our rules and see if there's anything that we need to add, clarify, or perhaps eliminate as unnecessary or outdated. Sure.
Just on top of the sunset review, next month, I believe, or at the end of next month in March, we're going to start our strategic plan listening tour, where Doug goes around, the executive director goes around the state and talks to stakeholders to get input based on that. I'm really like seeing all of the inspectors here in this meeting, because that helps form the process. It'd be great if you guys could also go out and attend those meetings as well, because they are for you guys to give input on kind of the direction the agency's going, because this forms our 5-year strategic plan. So if there's any concerns or issues, and we're coming to you guys, so look on the website for the schedule, which should be published soon, hopefully, and hopefully we'll be in an area where you guys can come out and give your input, so you don't have to come to Austin. That's all.
Thank you.
Michael Malloy, Standards and Enforcement Services. For report. First page reflects the disciplinary action we've taken since the last meeting, and the other two pages reflect the disciplinary action for fiscal year 2018, which starts September 1st of 2017. Stand by for any questions you have about any of the cases or other enforcement-related questions.
It's been 2.5 years and we still have people using the wrong form.
Yeah, if there's some questions regarding like the final one there, the one from November 15th, why there's a revocation versus a fine, that was a choice of the license holder. He used a 7-0 form, and sometimes we give the option to people depending on the situation. If they don't wish to pay the fine, we may give them an alternative form. He was retiring, he didn't wish to be in the practice anymore, and he didn't have the money or capability to pay the fine, so we offered him an agreed revocation in lieu of paying the fine. So there was actually 2 inspection reports, so, and he didn't have a DBA, so he was looking at least $1,100 on the lower end, so.
On the one that's November 2nd, 2017, is that one was that on our last report, that deficient inadequate cooling of an air conditioning system? Was that the one that the temperature differential inspection that was had?
I think it didn't come before our committee.
Oh, it didn't?
It only comes before our committee if there's something that really needs to be discussed.
Oh, okay, okay.
I don't recall. I mean, if it's from the last meeting, this first page, it wasn't.
Oh,
it wasn't
okay, I just
before
don't
you.
remember. I remember that there was some discussion, I think it was more, could have been more of an internet discussion amongst inspectors about how, what the temperature differential is that Trek is using to say that it was cooling inadequately.
We used it. We use this book, Principles of Home Inspection,
Okay.
and there's several references in here in regards to differentials, 15 to 20 and 14 to 22. And we use this as a basis because in the standards say inadequate cooling, it doesn't specify as necessarily a range. So we use this as a reference because this is what is taught to the inspectors.
Okay, I just wanted to clarify that, so we knew what.
That's where we got it from.
Okay.
Unless the standards specifically stated, then we would use that. If not, if it's a more general basis, then we use this as a reference.
Okay, thank you.
Just a suggestion to the committee members, since we are seeing several incidents of not using the current inspection report form, we may want to include an article in the next newsletter that reminds inspectors what is the current inspection report form and that they need to be using the current form. What would y'all think about that?
Really,
We've done that twice.
at least half of these situations is people not updating their software.
Yeah.
Yeah, 7.0 is a long,
That's
I
way
think.
more.
That was, that's a misnomer.
It's been a while.
Right.
Their software's outdated. Okay, so, education?
The first report is the fiscal year-to-date comparison as of December for applications received, licenses issued, as well as renewal activity. And you can see here that we continue to see a slight increase in total original applications received. We're up over 13.5% from 268 in 2016 to 305 in December of last year. Total reinstatement applications received, 5. Licenses issued from those applications, 273. And if you'll drop down to the renewal activity, you'll see that 226 inspectors have renewed their licenses, which is about 66.8% of those who were eligible to renew.
thank you for putting 2015 on there so we can actually, because the 226 versus 183 is actually more apples to apples comparison because they're on the same arena.
The next report is the report that provides for us the total number of license holders. And as you will see there in the middle, provides the total number of inspectors. We're at 4,060 as of the end of December, which is 318 more than we had at the end of December 2016. Are there any questions on this report?
I don't have any questions.
Well, it's active and yeah. I've never seen it about 2007.
Thank you.
Okay, and then the next report is our inspector examination activity. Again, it's comparing 2017 with 2016. We're focused on first attempt pass rate. Those are the individuals who pass the first time they take the exam. For real estate inspectors, that's currently at 33%, which is matching, primarily matching what it was in 2016. Professional inspectors are at 46.7%, which is an increase over what it was in 2016. It was at 42.5%. It appears to be improving for us so that if there are no questions on this report, we can move to the last report, which is a report on our total number of instructors, those who are approved to teach inspector courses. As you will see, we have an increase over that of December 2016. We've got 44 elective-only inspectors, 125 who are eligible to teach both qualifying and CE elective. We've got 54 who are qualified to teach the standards of practice, legal and ethics update, and 65 who teach the right and wrong course. Are there any questions on this report?
Any questions from committee members? Okay. Thank you. Thank you for staff for everything you do for us. All right, so now here it comes. Agenda item 6, discussion and possible action regarding proposed amendments to 22 TAC 535.211, professional liability insurance or any other insurance that provides coverage for violations of subchapter G of chapter 1102. And then that's A, and then B would be the certificate of insurance change that could possibly result from any motion or action taken. Kristen, you wanted to give us some information, please?
Sure. Included in your materials is a copy of the proposed amendment along with all of the various comments that we have received on the proposed amendment, both before it was published, after it was published, and after this committee, or after the last commission meeting. And as the committee members may recall, the committee recommended that the commission pass on adopting it at the November meeting to allow for further discussion. We have since received a lot of additional comments. We've also received some claims data from at least one insurance agent that we have summarized and provided in the materials. But even with all of this extra information, it's staff's belief that this particular issue is going to require some additional vetting and consideration by the full committee. So we would like to recommend that the committee make the following recommendation to the commission. And that would be that the committee recommend the commission take no action on the proposed amendments to this rule and remand it to the committee to allow for continued discussion and examination of a proposed legislative or statutory fix for all consumer recovery issues that could be implemented as part of the agency's sunset review. And so that is the staff recommendation.
Any discussion among the committee members on this? We have several public meeting comments. Should I do those first, or should we? Yeah, let's go ahead and take that, since
Well, if-
everybody came just, okay, go ahead.
If you want to open the discussion broadly for all of the all of the members of the public to speak, that's certainly an option. And another option might be to consider the staff's recommendation. If you are inclined to make a motion and second that motion, then you can still open it up for discussion after that motion. And so I leave that to the committee's
I think this
prerogative.
is an interesting change from where we were at the last meeting. Because I got the impression that staff was intent on going a completely different direction than what you're proposing now. But, I mean, a lot of people took time out of their day to kind of speak their piece on that.
So among the committee members, does someone want to make a motion based on Kristen's suggestion that we table this?
I make a motion that.
Reconvene and meet, and have a lot more discussion about it as a committee before we determine what we even want to do about it, if anything.
I would make a motion that we recommend to the commission that they take no action on this matter at this time.
And
Second.
Remand it
And
to.
remand it to the sunset.
As
Yeah.
fully, okay.
So,
Question. From the question. Well, we have the motion, we have a second, so now we're discussing.
So, in kind of elaborating on the second part of that motion, where you're talking, in plain English, kind of, I understand that it's kind of the legal term of the motion there, but in plain English, what is the intent of the second part of that statement?
Well, because the sunset determines,
Yes.
makes suggestions to the next legislature, correct? As to what directions they think they should
But
go.
the part where it's, you're talking about the overall, when you're talking about rolling it into the overall concept of
Consumer recovery issues.
consumer recovery issues, are there other things that are rolled into this that we're
Well,
looking at overall?
There could be. I mean, that could be part of the discussion. Inspectors are required by statute to have an insurance policy that allows consumers and provides consumers with a means of recovering for damages or for errors and omissions caused by the inspector. In addition, the statute also has a recovery fund that all inspectors pay into. And that's another method of consumer recovery. And there are certain limits, and there are also certain hurdles that a consumer has to go through before the consumer can receive any kind of reimbursement or payment from that recovery fund, including filing a lawsuit, going to court, getting a judgment, and going through a lot of other things. In addition, some of the commenters have raised the question of an inspector's ability to limit their liability or their exposure by contract. And frankly, considering that issue, it doesn't allow inspectors to limit your liability or your financial responsibility in the statute. That is nowhere mentioned in Chapter 1102, including in the financial responsibility provision. And if the legislature had wanted to allow inspectors as license holders to impose contractual limits on their liability, they certainly know how to do that. And what I mean by that is there are other license holder statutes out there where the legislature expressly allows the license holder to negotiate a contractual limit on liability with the consumer or their client. And typically we see those where the license holder and the consumer are on equal footing in terms of bargaining power. So most of those allowances for contractual liability are made in commercial contexts, not in general consumer contexts. So I just put that out there as, you know, a possibility that could be brought in to the fuller discussion. So those are all issues that are sort of tied into, you know, the responsibility to have an insurance policy or some bond or some other security that the committee may want to consider. You know, is it better to have an insurance policy? Or is it better to beef up the recovery fund and repeal the obligation to have an insurance policy? Or do you want to do it flip side and have an insurance policy that makes it easier for consumers? It also protects the inspectors, and then you don't have your license at risk if you have a claim paid from the recovery fund, because the statute right now would allow TREC to pursue revocation of your license if you have a payment paid from the recovery fund. So those are all just different issues that you know, could be open for discussion on the table.
From a parliamentary standpoint, if we continue with this motion to pass the ball over to the Sunset Commission, does that allow us to still make this discussion, eliminate that motion, and come up with some other idea?
Let me be clear. That's not what the motion is.
Okay.
It's simply, if the motion is adopted by the committee, and then what would happen is at the commission meeting, the chair, when this issue comes before the commission, would simply repeat the recommendation that is part of the motion and ask the commission to take no action on the proposed amendment. As a practical matter, that just means the amendment dies, because we have to take action on it within 180 days from the date that it's proposed. Otherwise, we have to repropose it. So it would die, but part of the motion is to remand the issue back to this committee.
Gotcha.
So it would still be within this committee's bailiwick to structure the discussion however the committee chooses.
Okay, thank you.
Or not.
Or not to.
Or not to, but I think that.
Well, it's, I mean, as the motion, it's to make a recommendation for a statutory fix, because right now, we already know that the defense within limits policies are in conflict with what the statute says.
That's part of where I'm getting into the question, is I don't see that specifically, because that specific statute says the inspector must maintain financial responsibility in the form of a liability insurance policy with a minimum limit of $100,000 per occurrence and an aggregate annual total of at least $100,000. And reading through the rest of that, I mean, granted, I'm not a lawyer, I just speak dumb English, but I don't see, I can see your position that this obscure lawyer brought up about if it's over 100,000 in defense within limits and all that other stuff. But I still don't see in the statute where it's at. But if you're telling us from a legal standpoint that there is one, then when it comes back to us, the fix that we're talking about may just be wordsmithing of the actual statute to eliminate that question mark.
Right,
or
to
something of that
clarify that the insurance policy could be defense within limits. It could be, you could also decide, well, maybe you want it to be a $100,000, $300,000 policy. You may decide to change the limits, because this is based on our feedback from the various insurance companies. This is a very strange policy because the occurrence limits, so the one-time limit, is the same as an aggregate limit. And typical insurance policies aren't written that way. You know, it's typically 100, 200,000, 100, 300,000. And if you look at all the states around Texas that require inspectors to carry insurance, their liability policies require either 250, 500,000 or $300,000, $600,000 limits on their inspectors. And when I say around Texas, I'm talking about New Mexico, Oklahoma, Arkansas, Louisiana, for the states that are close by that require inspectors to carry insurance. So it can be a simple fix to clarify that defense within limits policies are allowed, or you can consider other fixes that may better protect both inspectors as license holders and business owners and consumers.
I think it's my opinion to you guys.
I was gonna say, what do you think our ability is to recommend anything with the recovery fund? Because that's kind of been an oddball.
Well, the difference here is that the sunset review is going on. So everything's on the table now. It opens up doors that aren't necessarily opened up on, for other
we've discussed
legislative
trying
sessions.
to eliminate the recovery, and there were always arguments that we needed on top of our E&O. And that was always.
Well, I think a lot of that has to do with the limits on the recovery fund. It's only $12,500, and then the limits also on the E&O insurance as well. But if you remember, just a little bit of history, this was added on the last time the commission went through sunset, the requirement that inspectors have insurance. I believe that was part of the sunset recommendation. So anyway, just not to interrupt Chris, but just to add on it, the reason why, to answer your question, sunset allows for a broader sort of look at things, a broader recommendation. And so everything's on the table now in terms of that, the financial responsibility of inspectors and what works and what doesn't. And we have 12 years of experience based on when this was put in the statute last time, to look at to see where we want to go for the future, or where you guys want to recommend we go for the future.
Can you put your motion up on the screen?
Oh, I don't know.
I can plug it
I think
in.
it's important that we
But
take
we'll
the
lose it
time
on-
while we have the opportunity at the meeting to try to level the playing field between what the consumers can receive out of our inspectors' insurance and what we carry insurance for, which is the protection of inspectors also. And obviously, we're here because we care about our consumers having an option or an opportunity to recover something if there is a wrong against them and if it's been found to be something truly that an inspector failed at his job to do or find. But there's also the opportunity with this insurance issue and any kind of outside of limits for inspectors to go broke trying to defend themselves when their policy doesn't even cover what defense costs. So if we have an opportunity during the sunset review to come back and either find a better way to make insurance work or find a balance between insurance and the recovery fund, which a lot of people didn't want to lose to begin with, or write a better statute that allows us to buy or retain policies that are affordable, that the insurance industry can give us, that makes our businesses, not have so much liability. It's important for us to balance this out, because right now I feel that there's an imbalance between the consumer protection and us protecting our businesses against things that didn't happen or against lawsuits that are frivolous, because that happens all the time. And increasing our insurance only makes, like somebody else said, it makes it a larger magnet for things to click to connect to. So I think that tabling this and being able, I think that making this motion and putting it into another committee meeting and another discussion is probably the best opportunity we have as inspectors to fix what everybody thought was wrong with the first step.
I don't see a good way to fix this
Is it
right
broke?
now.
Is it broke?
And that's my other question,
Yeah,
is it
or-
broken?
yes.
I mean, based on the claims data that we received, 0.43% is what's actually effective of claims. 0.43% of total claims by this one particular person.
But that's only one.
That's why I
And
said.
so it could be 0.1%.
But that's,
Less.
it's exactly right, but that's why I said, it's just by this one, you know,
There's,
bit.
but there's all sorts of things that can color that in terms of that. I mean,
Absolutely.
if in fact, the majority of inspectors have liability limits in their contracts, that could cover whether someone files a claim or not. I mean, there's all sorts of things that cover.
Absolutely.
And it is just one, and that's not to say that it's not important data, that's why we included it, and we're happy to have it, that's why we wanted you guys to have it, but it's, you know, the vetting of why that is, I don't think has necessarily been done to determine if there is in fact an answer or an issue or even a concern to be addressed out there.
But the bigger number to me in that claims was the percentage of closed claims with no payment, which is 70%. That's the biggest number to me on that. People can sue you for anything, for any reason, merit or no merit, and that's gonna happen. I think if we try to take the defense within limits out, that's gonna be a huge problem. Number one, you can't get, I've talked to 5 different carriers, they're not gonna do that policy. But I also think that if we bump it to 250,000, that doesn't eliminate the potential issue that we're running into now with 100,000. Being that if it takes $50,000 to defend somebody, then there's only 50,000 that can go to the potential claimant. Well, let's just say we bump the 250,000, and it's a real long, drawn-out court case that costs 200,000 to defend. Now you still only have $50,000 to defend. So you've increased the price to inspectors. You put a bigger target on our backs as inspectors because now we have a much bigger piece of the pie that the lawyers can get a chunk of. And it didn't actually protect the consumer at all. So I think both of those that we've been talking about, that we talked about at the last meeting, are not reasonable solutions. But I think it's a statutory change clarification in that statute where you guys are seeing, where the lawyers are seeing the problem that we need to fix. And I think this is the only way we can actually fix it.
I don't think we had a problem to begin with.
I don't
quite
either.
frankly.
But I'm not a lawyer. Obviously, they're reading in a lot more to it than I'm going to see.
Well, we don't have
so.
anything to support that then.
Clarification won't hurt.
Just,
I can live with that recommendation,
Okay.
but I'd like to hear the public comment before we vote.
Absolutely.
just a comment on what you said about, you know, raising the policy limits. I know I talked about states surrounding Texas. Florida, not a state that surrounds Texas, but they also license inspectors, and their solution was to look at the average price of a home in Florida, and that's the policy limits that they chose to require inspectors to carry. So that's, you know, just
We could also
another
get into
example.
licensure requirements of inspectors in Florida and the substantially lower standards that they have and the liability that could be incurred in there too. So
You certainly can.
There's a couple
So
different
I
directions
mean,
to go there.
there's all sorts of issues that play into this discussion.
Yeah.
Okay, so we're gonna go ahead, since everybody made the trip, and allow public comments. Randall Ryden asked to speak on this agenda item.
Well, you pretty much hit everything I wanted to say, because I don't want to spend a lot of time. Yeah, I really don't see how the public's really going to, any consumer's going to be protected any more than is already in place, honestly. So, and it's like you said, the inspectors are not going to be protected. I know Shrek is not in a position to protect us, that's not the point. So we're kind of going to be out there in the wind with this, if it happens. I do agree that if anything, maybe increasing the, if anything, it's probably the wiser choice. I personally carry more. I don't think 100 is really sufficient anyway.
Thank you very much.
But he doesn't know that, he thinks he's normal.
Norman's his
I start-
legal name.
I start reading all these fines that get passed around here, so I'm kind of like reworking everything. So, actually, Lone Star Ashy, I quit polling after a while because it was just unanimous. I was just going to give the same answer and answer. So, our problem is, as a group, our problem is defense inside of limits being abstracted from that. Okay, so that it's defense outside of limits. We've really got a problem with that because in theory, it doesn't change the argument why we should mess with our policy in the first place. That's I mean, it doesn't change. If it's $300,000, I mean, if an attorney can't determine the value of a case and leads his client down a rabbit hole that sucks all the money out, and then he doesn't have enough money to get paid, well, he failed as an attorney. So and then when you look at the numbers, it just it reinforces what I'm saying here. Now, on a personal level, removing myself from that because I did not pull. I do not think raising insurance, my insurance, I think everybody in this room probably has more than the minimum. And I don't think us raising our insurance has put a bigger target on our back. We realize it's a responsible business thing to do. I'm not encouraging you to raise the insurance, but I don't buy the target. So, I mean, that's just a thought.
Thank you very much. Mike Collins?
Thank you. I had a pretty well-prepared speech to give today in anticipation of number 6. But judging from the way you're going, I'm going to keep some of my caps in the bag if you don't mind. But I would like to remind the council that, or the commission, maybe, excuse me, that this is business insurance we're talking about. And I know we have a statute that we have to go by. I realize that. I also know that this issue of the wasting clause is something that's very normally put in E&O insurance. This is a business decision. I didn't like it to begin with when it was legislated, but we have what we have. You are where you are. I would take quite a bit of exception as the way council is reading the statute, because very few around the table, or just a few around the table, were around in 7 when this thing was introduced. And it says liability insurance. It doesn't say professional. It doesn't say general liability. In fact, the question was taken to the AG, who also didn't have an answer. The tag liability insurance was put on it by TREC. So when TREC stands before the commissioners instead of a long-standing rule, no, it's a long-standing TREC decision. That's not necessarily a rule of law in this particular case, particularly when the AG says, no, I can't tell because it's what you said before. Just a couple of quick items, and I'll relinquish the floor. Increasing the terms of the liability under the description of the way the council has proposed to change the rule wouldn't do us any good, because the defense expenses would still be outside that. Bottom line is, what you pay today for your 1,000 or your 100,000, 300,000 would be have additions to it, whatever the defense cost came up to be. And if you had talked to some of the E&O providers, sometimes that can get up in the $80,000 range. Now that's an extreme, but that's a considerable amount over what we pay today anyhow for our E&O. That pretty much exposes the inspector community to a I'm out of business scenario. I also call back, or harken back to 2007 when this law was put in, and then the demand for E&O came into being. Our numbers as inspectors went down by a little bit more than 50%. The cost of E&O initially went up, although it came down substantially after that. And frankly, we lost about half of our providers in the state. They also, fortunately, were a big enough factor to where, a big enough market to where the inspectors, that inspector numbers in Texas warranted the E&O providers to come up with a brand new policy called 100,000, 300,000. So that was help. But remember the consequences, the effect on inspectors. I mean, I don't know how many of you have defended yourself outside of an E&O. It gets expensive very, very quickly. That's what I think. Thank you.
Thank you very much. And Fred, did you have a comment? You were on all, so I forgot to call you on all the other agenda items.
I'll just quickly add, I commiserate with the committee. I think kicking the can down the road to sunset is gonna be an interesting circumstance. I would suggest for you to consider discussing this topic further, because sunset's gonna come to each one of you and say, what do you think? And hopefully you, as a group, can come up with some type of direction rather than watching the legislature do what they want a week before the end of the session.
Thank you very much. Okay, so we have a motion and we have a second.
I didn't get to turn in a sheet, they ran out of sheets.
Oh,
Just
okay.
me.
We printed out some more, I'm sorry, John.
I'll write one up and give it to her.
Yeah, but go ahead.
Thank you. I can remember my password, right? I agree completely with the foreman's recommendation. It's wise, well thought out recommendation to defer this to future deliberation. It's actually, there's a question that I've been informally feeling about for 10 years, ever since they passed this law. And I've mentioned it to lots and lots of people, and I've never gotten an answer. And that answer is on the table today, that informally, Ms. Warman today stated that her personal opinion was that the statute does not allow you to limit your liability. So until that question is answered, the fact of the matter is that on every home inspection I do, I'm putting $100,000 on the table as a guarantee for perfect compliance with a very difficult standard. I'm guaranteeing perfect compliance. And it isn't, it's just an opinion of the staff member, but it's on the table, it's on that recording right there. And until this gets resolved, that's what I say you're looking at, basically. That's all I got.
Thank you very much.
I want to add real quick that when we went through this 10 years ago, we weren't really allowed to give a whole lot of input. I mean, on the E&O and all that, and now we're in a unique position where if we pass this, I don't like the term kicking the can, but it's going to come back to us, but we're going to get input, as an industry on where this should go as far as that liability is concerned. I think that's a good one.
I think the key word was liability. Is it general liability or is it E&O?
Right.
And we still never got a definitive answer from anybody except staff.
Yeah, there's assumptions, and that's something that we can specifically clear up, and that's a huge one.
I agree.
Yep.
And also maybe we will need to discuss any kind of statutes for our contract language. I know Trek doesn't really have anything to do with that, but if we have an opportunity with the contract agreements that we give our clients, where I know my contract says that I'm limiting liability, apparently that's a useless contract. But I would like it not to be useless because I paid for somebody to write it for me. So it would be nice to know that we have that more than just our insurance to blow through. If there's a big problem.
Contracts aren't required.
Right, that's true, not by Trek, but a business.
Not by all insurance companies either.
But, okay, so we have, go ahead. Oh, is there, Barbara, do you have any comments about what we've been discussing?
No, I'm totally with you. I think this is an opportunity for a deeper, maybe more complex look at a bigger situation.
Is the commissioner still in?
He is. For sure, yeah,
Okay. Commissioner, do you have any comments or requests?
If we're going to take this down and discuss it later, are we looking at only discussing it as a full committee or special subcommittee?
I would, my suggestion is that we discuss it as a full committee. I think taking it to a subcommittee kind of leaves everybody out, and I think that we all have enough input between the whole group, and then our public members, Barbara's here, but one of our other public members is not here, and that might be some input that would be useful. So I think that I'm not going to suggest a subcommittee, and that we'll meet as a full committee to discuss.
Good.
We could do it.
But she's right, you don't want to leave anybody out because you have a quorum or anything like that.
Yeah, and this is important. Okay, so we have a motion and we have a second. So do I have, all in favor?
Aye.
And.
Aye.
Thank you, and all against? Okay, so the motion passes that we are going to recommend to the commission to take no action on the proposed amendment and remand the rule to the committee to allow continued discussion and examination of a proposed legislative fix for all consumer recovery that could be implemented as part of the agency's sunset review. Okay. Agenda item 7, discussion and possible action regarding open book final exams for qualifying courses.
Just for the record, that was Commissioner Arriaga. For some reason, he's not able to get on here, but he did not have any comments or concern. He's hearing everything and he appreciates all the discussion, but he's not able to speak up for some reason.
Okay, so
the motion was adopted and we're on agenda item 7.
Thank you.
okay, so on agenda item 7, we do have Scott Reagan wanted to speak about this. You want to wait? Okay.
Did you want to review what the actual? Because I remember that discussion coming up from one of the schools.
I don't. This was
The
brought
last,
up.
the last committee meeting, there was a discussion.
This was brought up by a provider.
A provider,
Yeah.
in that they did not want to give final exams on the individual courses,
Okay,
was it?
thank you, Gwen.
So Gwen, can you speak to
I
this?
believe this one has to do with a proposed amendment to chapter 53565 of commission rules at the last commission meeting. That was to clarify, clarification regarding closed book final examination. And that clarification was added to make sure that all of the education providers were aware that closed book examinations are part of the approved design and delivery standards that became effective September 1 of 2017 for distance education courses. And the same applies to classroom courses. And for the committee to recall that the improved design and delivery standards were an effort by the commission and by the Education Standards Advisory Committee to better prepare our new license holders, if you would, to represent consumers.
Any discussion amongst the committee members before I ask for the public meeting comments?
So is that qualifying? Or
It's qualifying.
or just qualifying classes?
It's qualifying courses, right?
And the current rule as it sits is that the proposal is that those will all be closed book
Well, it's
examinations.
a clarification, it's a clarification. They've always been, staff's always considered them to be closed book, but this is a clarification when something came up that.
Yes, it was considered that as of September 1. Prior to that time, however, there was a time when, for example, distance education correspondence courses could only be offered through an accredited college or university. And at that time, we weren't requiring that those exams be closed book. Okay, but once we put the new design and delivery into, once we put that in, made that effective, the assumption was that because of the design and delivery and how stringent and what we were trying to make happen, that there would be no more open book exams.
So are we eliminating qualifying course examinations from being online?
No.
Then how do you keep people from having open book in their home taking the test?
Well, we do have the standards for, so exams now have to be promulgated, proctored, I'm sorry. And if that proctoring can take place online, but it has very specific requirements, a lot of qualifying courses are proctored through vendors such as Examity or ProctorU, and when we review those standards, we make sure there are a lot of things that are in place, which include you're not able to have multiple windows open at one time. They monitor, they have a visual on you. They can see movement if you move away from the camera screen. We do scans room scans, desk scans.
Or you could be required to go, like, to a library
Right.
or
And
somewhere
going to a
outside
location
your
is one
home.
thing. My thing is, how do you prevent people from having the book sitting right there while doing their test?
And that's really up to the provider, is what I'm hearing from Jen, but because they have to comply with these standards.
Right. And we review that. We review the process for proctoring that every education provider employs. It's been, I assure you, it's
just
stringent.
that's the first thing I think of,
Right.
people taking it online, so.
Right.
Okay.
And Gwen, just to make the understanding of the committee clear, this rule amendment was proposed at the commission meeting in November. So it's up for adoption in February, in a couple of weeks.
And again, it's just it's a clarification. It's not a new rule. It's just to clarify.
But the reason it's on here is that prior to, you and I discussed this prior, or after the meeting, one of the providers raised the issue about it. So we wanted to make sure that you guys had the ability to look at this and address this issue as it came forward, before it was adopted.
Okay, so public comment, Cynthia Carter with Champion School of Real Estate.
Hi, everyone. I'm the Austin campus manager for Champion School of Real Estate. Roy Carter is the director of our inspector program. He couldn't be here today. He did write a letter to the committee, and I would just like to read that letter so everyone understands exactly where we're coming from. Our goal really is to make sure our inspectors and they can do good inspections. Roy's very proud of the inspectors that go through our school, and he spends a lot of time with them, and our goal is to have the best inspectors in campus. So they're going to read Roy's letter. The request to address having open book exams for inspectors was brought up to the ESAC members as the October 30th, 2017. ESAC suggested that the topic be taken to the inspector committee for consideration of a waiver. The ESAC committee included inspectors when we voted to add the closed book language of the rules. Since the regular meeting for inspector committee is not until 2018, it was suggested at ESAC that Champion School of Real Estate reach out to the inspector committee to request an emergency meeting to consider a waiver to allow inspectors to take open book exams. The reasons are within this letter. We believe there are unintended consequences for the inspector license courses concerning the exams as it relates to the following, the same guidelines for real estate teams for QE and SAT, which was just proposed at the October 30th ESAC meeting. You may not be fully aware, inspectors have to wait 3 days to take a final exam if failed for 4, 6, 8, 16-hour courses. Inspectors have approximately 30 separate exams, most of which have a different number of hourly requirements. The issue at hand, based on the rule passed by ESAC that now applies to inspectors, is an inspector who fails an 8-hour QE course exam must wait 3 days to retake it. Is this an intended consequence of the inspector committee, since this is how it is now written by the ESAC? Closed book exams. My next question has to do with the closed book exam, especially as it relates to the 12 courses that make up the advanced course hours required for the professional inspector license to enable an inspector student to bypass sponsorship. These courses were meant to pull in the usage of available resources based on the topic which requires the inspector to become knowledgeable about using these resources to make an informed decision from their knowledge in the SOP. The majority of this information is very technical in nature. The IRC code book alone is a 5-inch binder and encompasses a lot of technical information. As you know, a professional inspector is required to complete a total of 330 classroom hours, 24 interactive experience labs, and 40 hours of ride-along, to reach a grand total of 394 hours to apply for the license. In comparison, a sales agent is required to complete a total of 180 hours, and a broker license is 900 classroom hours, which is obtained over a period of years. These two programs are totally different, and yet the rules are designed to keep them the same. There's the number of quizzes that our inspectors take and exams. So for the 200-hour course, they do a total of 560 quizzes, and total exam questions are 400. If the role of the ESAC committee listed proposed as one for the November commission meeting stands, inspector schools are required to recall SOP rules and IRC codes within course exams. Even the best of the best will find it difficult to recall rules and codes without resources. This is similar to TREC committee meetings. When questions are asked, rules are used as resources to review and to ensure the correct answer is being communicated. We want our students to learn and be prepared for the state and national exams, but more importantly, be prepared for the real world. They will be better prepared by looking at the rule in their research material and knowing the correct answer as opposed to guessing. We shouldn't guess rules. We verify them in written word. Open book exams require a genuine understanding of the material. The student must be able to interpret what is asked, think critically about the question, know what part of the rules and codes the material can be found. This is a process of reinforcing the structure, analyzing the various elements, and knowing how it relates to the rules and codes, and helps the student apply the material to new situations that will occur in the real world of inspecting. This allows the inspector to perform not only professionally, but with accuracy for the client's pleasure. I greatly appreciate the committee's consideration and value their thoughts regarding the issues brought forward. Thank you very much.
Okay, so,
Yeah, I was just going to just want to check in as well and I am with the, as well with the compliance and the delivery and the party. So, when we're looking at all of these courses, it is our utmost intention to make sure that that inspector is ready and able to go out there to the consumer. And so when you're looking at giving all of the questions with no resource to consider, when you're taking an exam, it's really just, as me, I would have a difficult time as well, no matter how much I know the rules. And so we just really do ask for consideration for the QE courses to have the opportunity to have an open book exam. And with speaking to verify what a student has, yes, we do have the ability when they do take the proctored exam to monitor what they have. They have to show us what's in front of them. They have to show us what they have so that we can make sure that there is, for lack of word, cheating going on and they don't know what they're questioning. So we do just really lean upon everyone to try to relate to that side of it. And we can talk about considerations. Thank you very much. Scott?
My only opinion on this whole thing, guys, is we studied a long time to be inspectors. You gotta remember this in the field. I did it when it was 980 hours, 40 hours right along, 25 for the sponsor. I spent 2 years doing it. And I feel that if you cut the corner on testing, you're gonna cut the inspector down to a minimum. I do as anybody else in this room. When somebody says something, I carry a code book, I refer back to it. But as I'm doing an inspection, I'm memorizing the code constantly. But if you take it away and say that you have an open book, it doesn't put it in memory. It's a mind memory game that you got to put in place. That's all I want to say.
I think that when you have an open book test, what you're teaching people is, here's the question, where's that in the book? Here's the question, where's that in the book? And that's what they're doing. They're going back and forth. And that's not what an inspection is. I think if it's a closed book test, yes, it's a shift change, absolutely. The education is going to have to shift in how it's done. But if we had a 70 or 80% first-time pass rate, I'd say this wasn't an issue. Leave it at open book. But we don't. We have less than 50%. We've had less than 50% as long as I can remember. So obviously, the information right out of the gate is not necessarily certainly not what they need to pass the tax. I think trying to compare this to the real estate side is not an apples to apples comparison, because yes, it's substantially less hours for real estate agents to get a license, but they also have to be supervised for 4 years too. This license is, the 390 hours is, you are out on your own with no supervision. You are out completely on the public. And you better be held to a much higher standard than that if that's the case. So I think closed book test, it's going to be a little painful, I think. But I mean, we still have education providers, even as recently as October, where you go do, we talked about this in the last meeting, you go do the legal and SOP class, and it's 15 minutes from login to certificate, you know, for an 8-hour course, and it's ridiculous. It should not happen, but it still does, even with the new class. So I think I think you're right. The more we allow corners to be cut, they will get cut.
I agree with Lee. You know, we're responsible for hundreds of millions of dollars of people's money and the decisions they make. And a doctor, when he goes in front of his board, he doesn't have any open books. He's just using his brain. And we have to incorporate as much knowledge as we can into the education process and prepare properly, be responsible for that knowledge when we take that final exam. I didn't get an open book when I took it, and I had to make adjustments when I took it the first time. And because of that, I feel like I was better prepared the second time.
I'd like to hear Gwen, yeah.
I just wanted to say that it's important also to note that the exam to obtain your license is closed book.
Correct.
And so the courses, the qualifying courses should be set up to kind of mirror or mimic that, if you would, so that you get a similar experience and know what to expect when you go to take the exam.
I agree.
The main exam.
Well, I'd like to say also, just contribute that, you know, as Glenn explained, the assumption, this is a clarification. The assumption was that all of the new design and delivery standards that were set forth are effective September 1st of 16, that had 15 months for distance education to become effective. The assumption was that the exam was closed book. When it came to our attention that some exams were being offered open book, we did some research, and what the correlation that we found is that those who were doing this were primarily those who had previously offered courses through correspondence delivery in association with a college or university. And like Glenn explained, we defaulted to the accreditation standard that the college or university had, and therefore we didn't oversee whether the exam was open book or closed book. So that's how, you know, that mindset, I think, just carried through to some of the providers who offered correspondence courses. And there was one on the real estate side as well that was doing the same thing. We discovered one on the inspector side, there was one on the real estate side. Both have been corrected. But I hear the discussion turning into whether you should or should not allow qualifying exams to be open book. But really the rule is still just a clarification that they are closed book. So that might be another discussion to make that change.
Yeah, I don't know that needs to be a future agenda item. I don't think the committee is intending for that to be a discussion. But, okay.
Having a closed book wasn't an issue. We thought it was. The issue was it wasn't clearly defined in the standards.
Right.
Which is what that rule, the rule is speaking to.
All that we've done is clarify the existing rule that was already posted.
And like Glenn said, the final exam you get to get your license is closed book. And I'm a firm believer that you should train the way that exam will be, which is closed book. You know, taking ICC classes, you train yourself on how to look things up. And if your mind sets that way and all of a sudden you get a closed book test, your mind is like in conflict there.
Right.
You really need to know it.
Any other discussion? Is there any, Barbara, do you have any comments?
It's a settled issue. It's not really up for change. So
All right.
it was a clarification.
Yes, ma'am. Thank you.
Mr.
Mr. Emmerich, are you still
I
on?
just agree with, I'll agree with everything. I don't believe that we should move to open book test.
Okay. Thank you.
You guys don't need to take any action.
Yeah, there's no action on this anyway. Oh, I'm sorry, John, I'm sorry.
John Cahill. You're going to hear both sides of this question. The fact is that home inspections are really wide, broad subject that covers every aspect of the construction process. And typically, I think closed book is just too difficult to memorize. And when I train people, it's more important to me that they know where to look the answer up. And I think that's actually a more vital skill. Do you know how to find the answer rather than memorize it? Because I don't think it can be memorized by someone who just came out of school. I think your pass test rates will go up. And I don't know if I'm making a correction or not, but Roy Carter's letter mentioned the inspector committee. I thought the education committee did this. So I'd like to give credit to this rule to the education committee and not the inspector committee. Lastly, and this has come up many times, is the standards have always been clear that it is not a code inspection. The home inspection is not code inspection. And the frequently asked questions that TREC has answered have substantiated that this is not a code inspection. So the difficulty is that several people in here today mentioned the International Residential Code as a teaching material. So the question is, we don't have to inspect the code, but TREC is approving courses based on code. And then the instructors are teaching code. And then the inspectors are testing on code, which standards don't require, which begs the question, why hasn't some of these students sued the real estate commission for making them study stuff that's not required? So there's just a conflict there. In code, all the code tests I ever took, they were all open tests. I couldn't have passed any of them without having an open book. The skill was being able to find the answer in the book and answer the question.
Thank you very much, John. Thank you, ladies. Okay, so no action is required. That was simply letting us know that they are clarifying. And so we will move on from 7 to 8. Agenda item 8, discussion and possible action regarding non-elective distance education course delivery.
This was added because of the issue you brought up last time. You asked for it to be put on the agenda.
Oh, okay.
So that's why it's on the agenda.
Yeah, and I touched on this just briefly a minute ago, that currently we were supposed to have gotten away from this, but in my last endeavor to do my 4-hour legal, 4-hour SOP, like I said, 15 minutes from logging the certificate. Just, I know, I'm a slow typer. But, I mean, it's an 8-hour course, and one of the comments that was brought up last time is, well, why should you be punished to take 8 hours if you already know the information? Well, it's not the point. It's an 8-hour course. I mean, you're supposed to go through and spend that time that's there, and I understand that you can't, I don't think you can really require people to physically take those 2 4-hour courses in a classroom. In metro areas, that's nice and easy, and it's, not a problem, but in your rural areas, that's going to be a little more difficult, to require somebody to do, and I understand that, but there's got to be some way that the education providers can be held a little more accountable to, I mean, the technology's out there. Defensive driving's been doing that for years, where you can't go forward to the next section until you spend X amount of time on this section. Not that I've gotten a couple speeding tickets or anything, I would know that, but I'm just saying, I know the technology's there, it's been there for over a decade. I don't understand why that can't be implemented on the provider side, and I would like to see that, because it's currently, at least with the one provider that I used in particular, which is not a small provider, it's not happening.
You have to look at the results of the, I'm sorry, go ahead.
Oh, no.
I think you have to look at the results of the passing and the failing of the courses that are non-time. If people are taking them in 15 minutes and passing them each time, they're showing proficiency. So we'd have to look at those details to really determine.
But that's not what the requirement is. The requirement is a 4-hour course and another 4-hour course. it's not, hey, if you know it, you can test out of
We
it.
should have the data.
If we want to put a stipulation in there that if you pass a certain test, you can bypass all the hours, I'm willing to have that discussion. I'm not saying I agree with it, but that's a different discussion. But our current standard says 4 hours for each course.
It does, and the Education Standards Advisory Committee vetted this and had substantial meetings with external providers, colleges and universities, when they were determining whether or not to include correspondence courses or to get rid of them. So the course that you took, Lee, is actually approved as a correspondence course. It's not approved as an online course. And that's okay. The correspondence courses, though, now have additional elements. They're not the old pen and paper mailing materials, typically kind of correspondence courses. But they do still have to meet certain standards. The committee decided that they would not be interested in establishing seat timers. And I think that's kind of what you're talking about, when you have to go into a course and it's a 4-hour course and I'm not allowed to access the final exam until 4 hours have passed, regardless of whether I look at the material or not. What we did is something different in working with ESAC, is come up with another set of criteria to determine whether there's enough material in the course to substantiate 4 hours, for example. The instructions that the student is given, and then and any other materials that may be included, for example, homework or quizzes. And after you brought this up, I requested login information from the provider from whom I took the course. And I agree that there is a deficiency in the legal and ethics course, and that's something that I plan to address with them separately. But I also believe that it was an anomaly, this particular course, because I looked at their other courses as well, and I saw standards for, essentially, I had to pass this in order to pass this, and then it wouldn't let me access the next homework until I passed the previous homework. And so there was a structure in there, and I think that's the intent with all of this particular school's other courses, and maybe just missing in this one.
I just kind of looked at it as I logged in, I didn't have to open any materials. I went straight to the homework, answered the questions, went straight to the final exam.
Right,
Done.
right. But in the other
Well, look,
courses.
it's because I helped write the course, but.
Right. Right. And this is the course that the commission, the commission wrote, the real estate inspector committee wrote with the real estate center. The materials are already provided. So again, I think that this one was kind of an anomaly that can be addressed. But as far as the other courses for this provider and other distance education courses for inspectors, they do follow a guideline. They have met specific criteria that include word count studies, and they do have the option of incorporating a seat timer should they choose to. Most, however, don't want to, and most education studies have veered away from that. There is something to be said for the individual who knows more than the average or a slower learner. But, and if you guys wanted to do something different for the inspector courses, you could, but that was the conversation, and that's how all of this came about through ESAC and the standards that they ended up establishing.
I guess I had just hoped or thought that we would have stricter requirements for the non-elective information, because it is at the core of what inspectors do and what our jobs are, is those 8 hours. I mean, the standards and the legal updates and that type of stuff. I mean, the other stuff is all elective, you can choose or not choose. This, you can't choose. Because of that, we as a state entity are telling inspectors, this is something you have to know.
Right.
And for them to be able to
Considering they're
skate through that
taking-
real quick.
They're taking this course year after year after year.
And it
Every 2
changes.
years, every 2 years, you've had your license for 10 years, 15 years, taken this course multiple times. If you don't remember it by now.
Well, first off, 4 hours is going to change every 2 years. That's part of why we changed it to what it is.
But like the legal ethics is what you're talking about.
Right.
That hasn't changed substantially.
No,
other
the
than
legal
other
ethics
than
is
the
exactly,
hour
the
requirement.
legal ethics, the legal update is 4 hours. That's what we just changed. That's going to completely change. The SOP can basically remain the same, But I can tell you inspectors been around for 5 years, 10 years, 20 years that don't know a lot of the standards.
Or which form.
Or which form it is. I mean, we see it, all you have to do is look at the disciplinary actions and know, and those are just people that have actually gone through the efforts to complain.
I think what Jennifer was saying though was that the particular course that you took was an anomaly.
Okay.
And that you shouldn't have been able to get through it the way that you did.
Okay.
And that she's been in touch with that provider, and that provider is getting that corrected.
And by the way, you're not gonna get credit for that.
Yeah.
Take it all over
You're gonna have
again.
to take it again and spend more time in front of it.
But are we,
They might not charge you for taking it again, but you'll have to take
yeah,
it.
I just want to make sure that there wasn't some loophole there that allowed them to do that.
It sounds like it is.
But it isn't, is what you're saying.
No.
All right.
I still think that, from what I hear you say and the way that you would like to see courses, you probably still not
Right.
like to see some of the things that you see, but they do satisfy the current standard and the improved standard.
Okay.
Thank you very much. Okay, agenda item 9, discussion and possible action regarding 22 CAC 535-220, including the inspector's relationship with and duties to the inspector's client. I think this agenda item was brought up based on Brian Murphy's data mining concerns with certain software providers.
Right, and then it's also just internally, looking at it, we realized, and just putting this on the table, this isn't any sort of thing, but the term client is not defined anywhere in the rules, so what does that mean? And that was something that other people on the committee have talked to me about just offline. Is that who pays for it? Is that who is on the inspection report? Is that who the inspection is intended to be for? So there's these kind of broad questions about that as well. So that's interlaced in this discussion, I guess.
Okay, so, I guess, well, Brian's not here. I was kind of thinking that he was gonna, he had submitted a lot of information, which I don't have that, I guess, is it in our materials?
It's in the materials, and we did reach out.
Okay.
To him.
And I guess what he's concerned about, well, I'll address what his concern, because I spoke to him on the phone, was that there's a lot of companies, could be software companies. InterNACHI's got a program where they are having homes inspected and they are the client, and then they take the data and turn around, and I guess they have information when you do the inspection on the house, and then they turn around and I guess resell that information. So they pay you as an inspector to do the inspection, and then they being the client can now do anything they want with it, which is post it online or sell it to real estate agents, or I guess however they want to deal with it. And then there's also another concern is like Porch.com and some of those other companies. I think HomeGate now has some kind of a deal with Porch, but they gather all of the data from from a home inspector's software when it's uploaded to their site. And they can now turn around and sell that information if they choose to. You have to, with HomeGate, I know you have to opt in or opt out, so as an inspector. So you have the opportunity to say, no, I don't want any of my data that's stored on a third-party server to be sold to anybody else or used anywhere else. But I let my clients know it's stored on this third-party server. The other issue, I guess, is whether we, whether we can or should or need to do anything about those types of companies, and how do we protect our clients other than telling them that that's a possibility. So this is what's up for discussion, is this topic.
Deal with the data when they buy it.
Two things.
Porch or home.
They're selling it to different providers,
Contractors.
roofers, plumbers,
Yeah.
electricians,
So there's a
whatnot.
lead generation.
But they're also selling the report to potential buyers. I've said
For $39.
For $39.
That's what
or
Internachi's
currently, or it's going to be
Or
or
whatever
whatnot. And I think, I don't like that they're selling it to providers. I think that, but that's its own issue. I don't know if we can actually get involved in what they do with the data. It's their report. But I think where we're gonna run into a real problem is when they're giving it or selling it to other buyers of that property. Because if there's a problem on that report, that next buyer's not my client.
Right.
You know, Internachi reports or whatever it is my client. So the buyer has very little recourse should something be wrong in that inspection report. That's a huge risk.
In our reports, most of the time, in our agreements and probably in the verbiage of it, they say they're good for the day. They're good for the time that we did the inspection. A week from now, something could have changed, the pipe could have frozen, and then we broken, and then all of a sudden the property's destroyed. And so you have a company like Internachi that you decide to work for, you're opening yourself up, I think, also for, a lot of issues down the road, because somebody's gonna say, who really did this inspection? Somebody's gonna ask, and obviously Internachi didn't do it, they just send one of their guys. So you're now a third-party consultant with some liability that's being sold, and I worry a lot of times when I have a home inspection that I legitimately did for a client, they didn't buy the property, but the agents all got a copy of it, and now they're taking your report and they're giving it to other people and not charging anybody else for an inspection. And now those people call you, and you don't really have to talk to them, but.
Nor do I.
And you shouldn't, because they're not your client, but that happens, and this is like 10 times worse.
Well, we think it's bad with lawsuits now. Wait till this starts coming around, and
And this
buyers start
is
getting a report that I did 3 months ago on another house, and they want to sue, they start wanting to sue people for it.
And this program, I guess, was supposed to kick off at the first of the year. I don't know anybody that's participated in it.
Mr. Cothran, do you have any input on that so far?
Yeah.
Are you willing to share it?
He's not on the-
Absolutely.
he's not on the public.
Actually, it comes back to liability again. My comment, but I think in this case I'll answer it for myself. If you answer a subsequent holder of your report first, because after the day of the inspection, it's probably not a good inspection or accurate inspection anyway. Second of all, you just increased your liability, and you violated a trust that Trek has placed on you that this is between you and the client, and that's it, and you can't release information unless you get their permission. But I think the liability thing for me is actually more, and they call me, I get the calls, just like Ray does. We all get them, and I am not going to talk to them, and I'm not rude to them. I offer them to do an inspection personalized for them with their name on it. But my fallback is that my client would have to approve it, and then I would have to acquiesce to give them anything, no matter how far beyond the date of the inspection. It's a no-go for me, and I think probably most inspectors. Any deviation from that would just increase the inspector's liability.
Thank you.
We have 2 public comments, and then I want to actually ask Kristen her opinion of any rules or regulations that inspectors have to conform to that this might be a problem for us. Obviously, legal is a big issue. Okay, so I had Bud, Roselle, Norman.
Okay, Brian's letter articulated it very well, and so, I just, actually I read the topic a little wrong before I circled it. I probably wouldn't have done that, but what happens with Internachi is that they are going to say that they bought the inspection report, and it's theirs to distribute. That at that point, that whole inspection relationship, whether it's with a seller, potential seller, or buyer, it's all become abstract, and it's lost focus. And Internachi is a home inspectors association that does not have a board of directors. Okay, or they do have a board of directors, but they're not elected. One?
One, yeah.
Okay, it's Nick Gormigo for the highway, and I have an interview that I have recorded, and I can back it up, but he says you vote in Internachi with your renewal dues. You're either with him or you're against him. That's what it's saying. And between the porch, the 200% report guarantee, the buyback guarantee, the 5-year roof approval, and with his education, I'm of the opinion, I mean, it's just me, I'm not talking for Lone Star, that's his buddy, but he's more like a vendor than an association. And with all these extravaganzas that are attached to our inspections, including the program he's talking about, the pre-inspection thing, our inspections are taking a back step to the extravaganza. And our clients need to be concentrating on the inspection rather than all the bells and whistles and merit badges and everything that you put on it. So him being a vendor, and this is just me speaking out here, I'm just wondering, home warranty companies, vendors, okay, they're under Trex umbrella. You know, education, they're under Trex umbrella. And if you got a vendor that includes so many services and does so many things for you, being an association or what, but why isn't Internachi under Trex umbrella? If you got, and not just, I'm picking on, using him as an example, but any company, there's a couple other companies out there that are like smaller Internachis, and they're not advertising themselves as associations, but when you get a vendor that offers so many services, it goes to your call center, goes into your inspection report writing, goes into your follow-up letters, which then also goes into other things. Shouldn't there be some sort of oversight into a vendor that does that much for our inspectors? Like a virtual company. It's just a thought.
Scott Regan, Terry, this whole program, has anybody heard the whole truth of the program? They're charging $39.99 for the inspection. You as the inspector still get paid the full amount that you would normally charge. And it's a free inspection. Under Trek rules, this can't happen. Read through it, because the client that is actually paying you is a subcontractor, is how it's worded out in the paperwork. I think the committee needs to read their requirements and how they're trying to put this in place. And yes, it did not go because the big vendors that were going to actually use this backed out recently. It was supposed to go live in Texas and Florida first of the year. The biggest inspection company in the United States was their provider. And they backed out. And I know the truth of that because they realized legally that there was going to be you were going to be the third subcontractor on an inspection. Well, I believe the committee really needs to seriously look at this as if it's a pre-inspection, it needs to be listed to the person that's selling the house or the estate or a family member. That's how the paperwork is processed, because that is your client. And I can't give that information out to somebody. I can't give it to anybody. Once I do the inspection and then they pay for it, it's theirs. I can't speak to anybody unless I have legal authorization.
I just have a quick question, because this is the one thing I was trying to get clarification about. So the pre-inspection part is there's an agreement with the seller.
That got contacted by Internachi to do the inspection.
So the seller says, yeah, I want, and they have, and who pays the inspector? Internachi or
Internachi, your fee that you would normally be paid to do that inspection.
Who's on the inspection report?
Internachi
is the client on the report.
So you become a subcontractor in that case, which is against Trek rules as well.
Is the seller paying Internachi?
Yes.
Sometimes.
No,
They
they
don't
don't
have
have
to.
to pre-inspection.
So they get a
Seller
pre-inspection.
gets it free.
That's
They sell it
that's
for
that's the other
Well,
question.
both
So they
ways.
get-
Originally it
so-
was listed for $39.99.
But
Now they're doing it free.
so they do it for free. So the person paying the inspection, the person on the inspection report is Internachi.
Right.
Okay. Thank you.
At least it's supposed to be.
So if you're wanting to sell your house, Internachi would approach you and say, hey, we've got this marketing plan.
We'll do a free
Let us
inspection.
do your inspection.
And we'll even
They
put it on
hire
the site,
somebody to
yeah.
go do the inspection. They take the report and then they make it available
To any buyer.
Well,
any buyer.
They take,
Anybody.
they take the
Anybody.
report and then they go to their list of subcontractors and feed them to the seller, hey, the inspection said you need new roof, or the inspection
Yeah.
says you need HVAC.
The
We
truth
have
is it
these.
automatically goes to Home Advisor. And they're a price group that matches pricing. It gets sold to 4 different vendors, sold to the vendors, which he also owns, to be truthful.
Yeah.
He's selling it back to himself.
Yeah.
And then you've got 10 calls from 10 different roofers to come out.
As a seller.
Yes.
Because they took the magnet and said, we do Christmas lights off and put the roofing magnet on their truck. Yeah.
And it's kind of.
That's what I'm going to ask Kristen from legal. Is there any way to force, because we all know there's going to be home inspectors out there and realtors there trying to promote this free pre-listing inspection. Is there any way to force disclosure of where these reports are going? So when these sellers let them in the house thinking there's going to be a free inspection done, they know their information is going to be resold.
Can I add to that? You have to be a TREC inspector under law license to provide the service in the state of Texas. So how can an outside contractor be providing a service as an inspection? Whose name, what's their life, because they're trying to sell an inspection.
They're only using the TREC license.
Yeah, they're not the one, but they're not the one performing the inspection. So I think that goes back to that whole question I talked about earlier that's interlaced, which is the idea of the client.
Who is the client?
Who is the client? Because you would ask that question
Well,
about
I had asked
something
the
as well.
question because it had come up in an online discussion about client, and we all kind of perceive the client as the one to pay for it.
That is.
And the question came up, I do a lot of them for, parents are helping their kids, and like the parents in New Jersey are paying for this inspection, but it's for the kids that adult kids.
Right.
That are buying this house. Or I do a house, say I do a house for a relative, and I'm not charging anything, so there's no money. Nobody's paying for it, so there isn't a client. I don't always have the same person that pays me is signing my inspection agreement. Who is the client? The client, to me, is the one signing my inspection agreement.
The one
And
who the report is for? Or-
Yes, yeah. So my client is the one that's signing my inspection agreement.
Regardless
Is
of who-
usually-
regardless of who pays for it.
Yeah, it's usually who pays for it, but not always. I've had agents that really wanted to promote this house, and they offered to the buyers, I'll pay for an inspection for you. But my client is still the people buying the house.
Paid for by Realtor so-and-so.
And I don't,
Well,
do I have to disclose who paid for it? Because I might not even charge for it. I may do it for free.
You have to disclose who paid for it.
Why?
Yes, the Realtor pays for it. That's a rule I recall from way back.
I don't.
If a
I'm
realtor
not-
pays me, writes me a check for a home inspection for a home buyer, there's a conflict of interest there. If I put the Realtor on there, right?
I'm not putting them on anything. I'm
The
cashing the check.
transaction's going through the Realtor.
There's no implied.
Well, I'm putting it on.
Well, there's
I'm
no
making it
implied
very clear.
relationship or any evidence of collusion just because the realtor paid for it.
Okay, that's not unimportant.
But I mean, so it comes around to defining the
The
client.
client is the person who's buying the house. That should be the client.
Regardless of who pays for it.
That's
But
what
what
we're
if-
designed to do. We're designed to protect the home buyer.
And that's my belief.
Well-
But a lot of people tie it to who wrote the check.
It should be the person, this prospective home buyer.
Go ahead.
Yes, sir.
I mean, as far as TDA goes, they specifically say on the WDI, name a person purchasing the inspection. So that's who is named on the WDI as the client. I know we're not TDA, but a lot of us do WDIs too.
I put multiple names. If I have an opportunity to put more than one name on my inspection report, and that's what I'll do. If I have, like I had a gentleman who we did 3 inspections for, buying a house for his mother. Well, he wanted his mother's name on everything, but he also was the person that I was sending the report to because his mother wasn't going to look at the report. So I put both their names, and I put on the invoice who actually wrote the check, just so for my records as a business person in case something happens. But I put both their names on the report, and I don't know if there's anything saying that we can't put more than one person's name on
But
the
are you,
report.
I mean, a lot of places in our rules use the word client.
Well, they're both my clients. He's buying it on behalf, he's paying for the inspection on behalf of her, she's buying the house. But to me, I have the opportunity, if she calls me, to talk to both of them. So so I'm not gonna not talk to her. So I put both names.
Is it a gray area?
I agree with that. I mean, if you want to open up reduce the liability, anybody you put on the contract and/or the inspection report should be the people you're allowed to speak to. Those should both be your clients.
Because it does restrict our disclosure to the client, so the question is, who's the client?
See, this is what the statute says. Client's not defined anywhere in the rule, and then the statute says accepts employment to perform a real estate inspection for a buyer or a seller of real property. That's how each level of inspector is defined. That term is in each one of them.
We should actually wouldn't be a buyer or a seller.
Right. Well, let's go back to this, they're doing a pre-inspection sale. So it is a real estate transaction.
But it's not for we're not doing it for a buyer or seller, we're doing it for an association.
Well,
there's
No.
problem.
You're doing it for the buyer.
I don't know who the buyer is.
I'm sorry, the seller.
But I don't know who the seller is.
You're not even doing it for the
I'm
seller.
getting a contract
You're
from
doing it
them,
for a third
actually.
party.
They don't even tell me.
But I think if I may say, and this is not to whatever, but the other, this I think also plays into it, accepts employment. What does that mean? It's not defined in the statute. Does that mean that the person is the buyer or the seller, or can it be someone outside of that who's employing the inspector to do it? So I think that's why the confusion comes with the actual definition of what a client is. Since it's used in the rule, and rules have the ability to clarify things of that nature if they need to. So, I mean, if this is an issue, that may be an approach to take, is to try to clarify what that actually means.
Money needs to be in escrow. So if a seller offers employment.
Why does money need to be in escrow?
Well, because then you've got an agreement on the purchase of the property.
This is a pre-listing.
I don't think we need to be doing pre-listing
Purpose.
inspections. I think we need to be protecting home buyers, not sellers.
They would be the home seller. They're thinking about listing their home, they're the seller.
I personally don't
And-
work for sellers.
Well, you don't have to, but you
I
can't
don't
put that
have
out
to.
3,000 other inspectors.
I'm not saying that we should cut them all out. It's a determination you should make, but I've looked at many pre-listing inspections, and they're wrong. There's mistakes galore in them.
Well, I can say that for all
I say
inspections.
that's for all,
Yeah.
whether they're for pre-listing or for buyers.
Show me a
Okay.
perfect inspection report.
I mean, the inspection isn't any different. The inspection I would do for
I think
Tony
the
listing a
inspection
house.
does become different with some inspectors. I think they feel that they can gloss over some of the things that are less important details.
That's them.
Yeah,
And
but
that's
the
them.
standards, you still should be following the same standards.
There's only
Correct.
one standard.
Correct. If they're glossing over things,
Right.
they're not doing things properly.
That's an integrity.
That's a
I mean, we're
standards
bottom
issue.
line, we're allowed to do pre-listing inspections, so
I
we
know
just
that.
need to figure out how we protect the consumer, because the consumer's gonna be harmed under this InterNACHI program.
Yes, absolutely.
I feel like that too, and their privacy. Kristen, do you have any input or suggestions on?
Well, like Tony has already alluded to, the fact that neither the rules nor the statutes define the term client. That certainly would be an opportunity for this committee to provide some clarification. The rule that is in your materials, 535-220, states that inspectors shall not disclose inspection results or client information without prior approval from the client. So to the extent client remains undefined, that rule is somewhat vague and doesn't really help you in determining the answer to the questions raised by this particular scenario. From an anecdotal perspective, it's no different than you logging on to Papa John's website and ordering a pizza via your email account. There's nowhere on their website, perhaps except in the I agree to the terms and conditions of the use of this website, which we all know is printed in very small print and
Everybody reads.
yes, and everybody reads that before they click through that button because, you know, they're not hungry and they don't want their pizza to come today. They want it like 3 weeks from now. But Papa John's actually makes more money selling email addresses than they do selling pizza. Because they collect all of those email addresses and then they resell them, just like this business model does. It collects information and then it resells them. I don't know that as a committee we can prevent the resale of information. We can clarify the definition of who is the client. One example, in a legal perspective, it doesn't matter who's paying the bills for the attorney. The client is the person that the attorney is representing. So you have a car accident and you're at fault, so you contact your insurance company, and your insurance company says, oh yes, we'll defend you, we'll pay for everything, and if the other party sues you, yes, we'll pay your defense costs. The insurance company is paying the bills, but the attorney is representing the policy holder. And, the same is true with your own liability insurance. Even if you get sued, the insurance company may pay your defense costs, but you're the attorney's client, not the insurance company. And so the insurance company has no right to be involved in those privileged discussions between the attorney and the client, except to the extent that the client allows, which is what our rules say. You can't disclose the reports without the permission of your clients. So that's one way you could go, is to define clients, not to include somebody that pays you, or if you include somebody that pays you, then they would be subject to the same restrictions. You'd have to get everybody's permission if you wanted to disclose that report. The person paying you and then the person who you're doing the actual inspection for. So that would be a consideration when you're talking about how to define client. Another possible solution might be to adopt a disclosure that we would put in the either in the preamble or in the other consumer disclosure notice to alert consumers as to whether or not their information could be resold, or if you have a plan to resell that information, so that when you go and do that inspection for InterNACHI and you're meeting the seller to do that pre-listing inspection, you would hand this disclosure and you would point out in the disclosure that this information could be resold. Brian Murphy's letter raises a whole lot of other issues that this committee has touched on in past discussions. What about photographs in the report? What about privacy issues? And as a regulatory body, we can't address those. Those are already addressed in the legal system, and consumers, to the extent that their privacy has been violated, the law allows them to file suit for the violation of that privacy. So they could then sue InterNACHI if InterNACHI is the one that provided this so-called free service to them.
And didn't disclose what they were going to do with the information.
Correct.
Well, I think,
which may be one of the primary reasons that the vendors pulled out of this agreement to, start this program.
the fact that InterNACHI is selling the stuff, or selling the information to different contractors that contact the seller, honestly, I'm not nearly as concerned about that, because when the seller signs up for this service from InterNACHI, they're opening that floodgate. You're getting a free report, nothing's for free, there's always gonna be some little catches. I'm sure it's in their agreement that you're gonna get contacted, if the inspector says the roof is bad, you're gonna get contacted by roof. That's between InterNACHI and the seller. My concern is the buyer on the other side that has bought this, report for $39 or gets it for free, whatever the case may end up being. They get that report, and and they have no one to talk to about it. And you basically just have the factual information of the report, and that inspector's going, or really should go, I can't talk to you about this, you're not my client.
Well, and that could be
And
part of the
that's my
clarification.
concern from the consumer standpoint, where I think the consumer liability is when an inspector is hired for an inspection, you aren't just getting the actual process of the inspection, you're getting the consultation, the education. And that's a huge important, it's just as important as the information you actually put on the report is training, educating the people on what they're actually buying. But you're taking that whole component out by doing this, and I think that's where the liability of the consumer comes in. But how do we fix that? I mean, how do you?
It sounds like defining client resolves all these issues with Aeronaci.
I mean, it can help resolve many of the issues. The other is just education. I mean, we have our new SOP course, and this could be one of the hot topics issues that comes up. Especially if we do move in the direction of defining the term client and who is the client, then that's something that we would want to put out there, either through our newsletter, education courses, to just educate license holders and put them on notice. Look, when you're doing this, or not when you're doing this, but when you receive calls about a report that aren't coming from the person you did the report for, then this is the best practice of how you address those calls. Both from an inspector protection and a consumer protection perspective.
Just a quick question on accepting employment. That's basically the person who's writing you the check, right? The person who finances that employment is the client at that point. Not necessarily. That's what I'm
Not
wondering about that
necessarily.
definition.
I mean, you're accepting employment is the employer could be the person who's paying or writing the check, as you said, but the client is, even in the statutory language, if you'll pull that up again, it says employment to perform an inspection for the buyer or seller. So the employment could be the payer, but the client could still be limited to the buyer or the seller.
Another issue here is down the road, you're going to see Aeronaci or the representative from Aeronaci start getting involved in how that inspector writes the report, and how they word such a report, and possibility of going to the lowest bidder, to get the better price because they want to pay less overall. But I can see the integrity of the reports going substantially downhill because they know that the buyer isn't going to have the benefit of having that walkthrough with the inspector, so they're going to be, well, can you word this a little differently? Technically it's true, but can you word this a little differently? And I can see the integrity of the report starting to go downhill and stuff like this too.
And the answer is, if Aeronaci calls, don't do it. Don't do the inspection,
But
and don't give them.
When you're hungry, you're hungry.
Yeah, somebody will.
Well, and as a license holder, just to give you a comparison, appraisers have the same problem when they're doing the appraisal. And now there are federal laws in place that prevent lenders from, being too heavy-handed or overreaching whenever they're looking at an appraisal report and requesting the appraiser, oh, hey, could you reword this? Or, hey, you really need to consider this. Could you reconsider this and, either bump this up or knock this down? And, as a license holder, at some point it becomes incumbent upon that license holder to just push back.
Yep.
And say, look, this is my report, and if you don't like the way I wrote it, go hire someone else. And so there's a balance there. And
Buyer and the seller has to be more clarification. We all deal with investors, we deal with family estates and everything. I do the same thing. I put multiple people on my inspection report. The whole thing comes from is you're being asked to do an inspection not for a buyer or seller. It should not be allowed in city effectively. Because direct rule says for a pre-inspection for a sale has to be 7-5 report. That's just basically clarified.
Well, you can still do the inspections for anybody or anything, but it may not come under the rules of TREC.
But if you're doing a pre-inspection report,
Yeah.
it has to be done on
Yeah.
7 days prior.
Part of, part of the sales transaction.
Yeah, but the idea that you.
If there's no transaction, it doesn't qualify.
That's not necessarily how
If
we've
it's a
interpreted
pre-listing
it.
inspection.
If
anticipation
if it's a pre-listing, that's different. If somebody calls you and wants you to go inspect a home.
Oh, yeah, that doesn't apply. It's like a warranty
That's right.
inspection.
That's right.
But it
Same
says
thing.
if
Yeah.
you're employed, which means money transaction acquired, then it's a buyer or seller. It's just written on that one sentence, and that's how.
That's the trouble
That's
with
the
that one
legal
sentence.
term of it all.
I can
right
be
there.
employed by a homeowner
That
all
doesn't
day
have the
long.
intent to sell.
Right, but
That
you,
has-
but then
Right,
that's
and
not
then
a.
the standards don't apply.
That's not, and I'll do a
this
track
is-
inspection,
We're
but
all
I
getting off
don't.
the page, just stay with it,
Yeah.
and I apologize, but it's a pre-inspection report.
Yeah.
Somebody trying to sell a house, that's what it's coming down.
Pre-listing, pre-marketing.
Pre-marketing, pre-listing, it's a pre-inspection to put it on the market.
Anticipation to sell it.
Exactly.
So it's part of the sales transaction.
Yes.
That's what the whole law says, you can't do it in the state of Texas.
So who is the client when you have a house that's being leased and the tenant wants it inspected?
The homeowner has, I've always
the
read the
homeowner
homeowner has
authorizes
to
that.
give permission.
Right.
And so if the homeowner gives permission,
Who's your client though?
the client is probably the tenant who's gonna go back to the leaseor
But
and
they're not
ask
buyer
them to
seller.
make.
But
That's
you have to
what-
get written permission by
By the
the
homeowner.
owner
Right.
to inspect.
Who's
So
So is the homeowner the client at that point?
But it's not a pre-inspection.
I know.
It's not a track inspection.
It's not a
It's not a
transaction.
track
transaction, there's not a transaction to buy or
So
sell
it doesn't
a home.
require the 7.
Correct.
Yeah.
Unless the tenant is looking to
Okay, for
purchase.
Right.
And like a lot of things that come up, unfortunately, when this language is written, the current situation was not contemplated.
Right, yeah.
So,
So this could be a, we're looking at a future agenda item, basically,
Yeah.
is when we need to discuss.
I think defining the client
Yeah,
is probably
defining,
primary.
defining client for sure.
Would that be a standard practice?
yeah, what sub, if you want to do it to subcommittee, which one would it go through?
Conflict of
I,
ethics.
that they need to directly.
Enforcement, maybe?
Yeah, I would think.
Or
Possibly
enforcement.
could go to enforcement, I guess.
We have one more person that.
Well,
Mike
enforcement.
Marlowe, real quick. Yeah, I've been following this whole thing too. There's a lot of information that's being thrown out here that was initially thrown out 2-3 months ago. The proposed program has drastically changed since all that information was thrown out. And many, many times over, if you know Nick Gromyko, you know that he throws an idea against the wall. He lets everybody beat it up until it finally either dies or comes out in a new, different form that you can't even recognize. So I'm seeing a lot of panic here, questions that, you know, probably aren't even ever going to be seen. So, yeah, I'd say watch it. Just not watch. Watch to see what actually comes out.
I think even if none of this comes to fruition, the question still remains.
Question
We gotta
remains.
define client. I mean, it brings up,
Yeah.
whether this actually happens or not, it brings up a good question, and we have to define the client a little more specifically, and that probably would not be a bad thing, not just for this program, but any other program that comes in.
I mean, anybody that's doing seller's inspections, if you're doing a pre-listing inspection for the seller, you know, the way I do it, I give them the report and tell them, you know, either fix your house, or if it, you know, wasn't in bad condition and, you know, you just want to disclaim a couple things or whatever, you know, use that report, market the hell out of it. Yeah, use this to sell your house because, you know, that's what the purpose of the inspection is for.
Well,
But
they have
then
to-
you
It's expected to be
their-
sold.
But then you and your client, the seller, have come to an agreement that the reason that you're doing the report is to either make the house more marketable or give them, you know, a long list of things to fix, and maybe they fix them and you re-inspect and revise the report. But that, you've already agreed that that's a marketing tool that you know they're gonna use, and that's different.
No, that's
But-
exactly what this
yes,
Nachi program
yes.
is.
Well, and the seller, they don't need to get your permission as a license holder to disclose that information.
Well, no, in fact, it's on this new seller's disclosure that if you've had an inspection in the last 4 years, you have to disclose that.
You just have to disclose what you want done, you don't have to disclose the report.
You're supposed to disclose
Well,
that one.
it's not on the
Identify who
statutory
did the report
one.
when it
And
was.
it's been on the DFW one for at least 8 years, as long as I've been working,
Yeah,
as long
I
as I
mean,
looked at it.
yeah,
It's not a recent thing.
Right, but you
It's-
better disclose it. You better
it's-
disclose the report if it's there, because if you don't
It's a
material defects in the
liability
property, you
related
have
issue, so.
Okay, so that's another discussion.
I have a quick question for Kristen.
Okay.
Who's the consumer? Is the seller the consumer?
Why does the, I mean,
Because my thought was we're here as a real estate commission, or at least as an inspector committee, to protect the consumer, not the person who's got an interest in.
The client can also.
Well, I'm just wondering who the consumer is. What is, what defines a consumer? Someone who's consuming a product or service correct? Is that right?
in a broad manner speaking, yes.
I'll find out. I'll look.
Yes. But I mean, you know, in this context, you could look at a consumer as being the buyer or the seller, the person that hires the inspector, or in the situation we were discussing, the consumer could be somebody who receives the report from the client or gets a copy of it, you know, later down the line. But in that situation, the consumer doesn't have privity with the inspector because they weren't a party to that inspection transaction.
Thank you.
Sure. And as far as how do we come back with a rule, I mean, the committee can direct staff to, you know, draft some proposed language and a definition of client. You probably want a little bit more direction, and it doesn't have to go through a subcommittee. It could come back to the full committee if that's your prerogative. You know, but we could consider things like, you know, defining the client, can there be multiple clients, and consider the issue of payment. Does that impact the definition? So.
So I'm not sure that this particular discussion has any action on it at all. We will just put it as an agenda item
The action will be directing staff
to,
come up with
okay,
some-
for future meetings. We'll come up with some language that defines better. Fred Beck would like to speak.
If I could, I'm Fred Buck, just on behalf of, just to verify with the correct staff, the comment was made that there's a requirement that says that you had an inspection in the last 4 years, and that's not correct. That information is on a TAR seller disclosure form that is not on the TREC form.
That's what I just said.
Right.
I said it's not a
Yeah, I never said it was on
statutory
the track.
requirement.
So to clarify that point even one step further, last week at the broker lawyer committee meeting, there was an agenda item, has an amendment 39-8, and it's an amendment to contract concerning the property at this address to add some more information pertaining to the repairs and treatments. The repairs and treatments are taking off of our inspection reports, and as a result of using this document, they won't have to include a copy of our inspection report between the buyer and the seller. They'll just transfer what they want from our inspection report directly to this amendment and avoid having shared inspection reports anyway. And so that's something that this committee needs to be aware of also, just to pass on to the inspectors.
Thank you very much. Okay, so we'll look for from TREC staff some help with the definition of client, and then that will be in a future meeting. Okay, agenda item 10, discussion and possible action regarding an inspector's responsibilities to the property owner of the property being inspected. This committed in the last meeting.
Yes, this was just put on here because of the discussion about what are the responsibilities of an inspector when they're doing an inspection, and the buyer or the buyer's agent is sending people over to the property when you guys are on.
Right.
We've opened it up.
Yeah.
Yeah.
We've opened the door under our ABOR, whoever, our MLS key, which is to me what gives us the opportunity to get in a house if we have that key. So we are now, once we open that door, the way I look at it, responsible for whoever walks through it.
And whatever they do.
And whatever they're doing in the house, even though we may not know who they are or why they're there, because the realtor sets it up and doesn't show up. So we've got a roofer, we've got somebody that's gonna measure the floors and put new carpet in or whatever. And then we have, clients that come in with multiple friends and family and children and
Dogs.
pets. And so I guess what this discussion was is, are our responsibilities defined by TREC, or are they truly only defined by our MLS access? And is there anything that we can do to, or should do to limit our responsibility or liability on this piece of property?
Right, and the question is whether this is even under the umbrella of
Right.
regulatory action. So,
Me personally, I don't think it's gonna be a TREC thing, I think it's an MLS. Because MLS, governs the access of any and all properties, whether it's Netris or whatever the case may be. And Brad and I have differing opinions on if the house is occupied. I have a personal business decision that I don't let people in the house while I'm conducting the inspection. I tell them, hey, come at this time, we'll do the walkthrough and whatnot, but while I'm doing the inspection of the house occupied, I don't allow them in there at all, because I can't babysit what people are doing. And I've caught people going through drawers and shelves and looking at clothes and stuff like that. It's a huge liability, but I don't think as an entity, TREC should be involved. I think it's an MLS access. And our MLS actually prohibits people from being there unsupervised. And if you're doing an inspection, you aren't supervised.
Well, you would think that the realtors that usually send all these people over would have the same information about what MLS access is.
Well,
as we do.
they like the idea that the house will be open and they don't have to be there.
And they don't have to be there. That's the way they look at it.
So they may be late. No, they're just taking it, well, we're
They're
opening up
taking
the house,
advantage
taking
of your
advantage of
3
the house.
hours or 4 hours of being in a house, for them to have an opportunity to send,
Because most of the brokers in our area have rules with their agents that they are not to be there at the inspection.
Correct.
Because they don't want to be exposed to part of the lawsuit that may or, come about.
Forthcoming.
But I've got agents that will show up and they'll unlock the house and they say, I'm not allowed to go in the house, call me if you need me, and they leave. And that's just a local rule. The brokers in our area pretty much have the rule that I know for the last 25 years that they don't like their agents in the house at all or around. But that means the buyers, they'll encourage their buyers to be there. Now, I'm dual role, I'm inspecting and babysitting.
Are the sellers usually there?
No, they tell the sellers not to be there.
Because they don't. You don't want the seller.
They don't want them talking because they may get some information that
But
they'll
that's,
want.
unfortunately, that's happening, especially during the holidays and things like that. This time of year, it happens a lot, where you have sellers home, you have buyers, you have no realtors, you have just people wandering through property and house and talking to each other. That's not our responsibility. The way I look at it is, I was hired to do a specific job if the realtor is sending people over. I don't know, I guess make a note of who came to your inspection.
I just put who's present at the time of the inspection, buyer, seller, at least.
Yeah, I put that on the report, yeah, so.
But it doesn't limit your.
It doesn't limit our ability, but take a few pictures, I guess, and that's the only way to maybe cover yourself.
The only way to do it is what Lee does, just don't let them in.
Don't let them in. John?
Just sit them when they get there.
Yeah, I agree with all these problems, and we all have our own ways of managing it. The Texas Association of Realtors last week was publishing in their newsletter, can my unlicensed assistant go to the house and open the door? And they came back and they said, TREC says no, unlicensed assistant can't go there. So what's happening in the industry on a widespread basis is, and basically, if you don't want to do what the realtor wants you to do, she's going to find a different inspector, okay? That's how it works. But technically, I think TREC could actually say that if the inspector's allowing the buyer and the remodelers and the engineer and the appraiser, if the inspector's letting these people into the house, that they're actually acting as the agent's assistant.
I think that's a real
That's a
slippery
stretch.
slope there. That's a big stretch.
Maybe they're not being compensated,
That's a
right?
big stretch, because now you're assuming some relationship between the agent and the inspector, and that's not a relationship we want people to be thinking about.
But
So then we're not acting as an assistant.
when you're left in a house
We are just
for several hours with a client without an agent present, invariably, and maybe me not so much, but the inspector is going to be caught practicing real estate. I can get that fixed, right? I can't tell you that. And I can't, is this a good price for the house? We've heard all these questions.
Should I buy this house?
Right, we've heard all these questions, and we're showing a house, and we're licensed home inspectors, we're not licensed realtors. So there is a lot of room for these questions that,
Maybe there's something as a committee or all the commissioners are members of TAR, and they're all, maybe there's a.
The realtor members
all
or
the realtor,
the agent,
broker
licensed members.
Right. And it seems like they would understand if there's, maybe we should ask for guidance or something, or maybe it's just nothing we can do about it, except they say, hey, it's a.
Staff might
We're not
exposed. It occurs to me that there may be something to do with fiduciary responsibility in the agent involvement as well.
Yeah.
From an agent's perspective, if, and maybe it's different but in our area, almost every inspector has a super key, electronic key to get in, it records who's there and whatnot, and that's through the MLS. But in a situation where an agent has to come and let somebody in, that agent is still responsible, period. Because whether they stay there or not, because they granted access to that property.
Right.
So if their broker is telling them you can't be there, that's an issue between them and their broker, because if an agent lets me in, I don't think I've ever had an agent let me into a house and then leave. It's just, I guess it's just different. I open that box, and then in the end, if that agent wants to hang around, if the agent's there with the buyer and they want to hang around, I put key back in the box, and I make them open the box back up before I leave. So their number is on the back side of that record.
Yeah, I do the same.
Because I've had agents take the key, when I hand it to them, they took the key, put their own lockbox on it, and had contractors replacing the floor before the house even closed. That stuff happens.
Sounds like this is a new course.
Responsibility.
Yeah.
Fiduciary responsibility.
For realtors,
So I
for
don't-
inspectors, to know.
I don't know if there's any real discussion or action more that we can really do as inspectors, because I don't feel that this falls under anything that Trek is regulating for
Well,
home inspectors.
because we don't regulate access to the home.
Right. Yeah.
That's controlled entirely by MLS or by an agreement between the buyer or the seller or whoever the client is to let the inspector have access to the house.
So this would be where inspectors would have to have discussions with the agents individually, I guess as the problem arises, and ask them if you're gonna send over all these people, maybe you need to be present. Or you do it at a time when you're here, like this week.
Isn't there a line with the sales contract that addresses this about, the buyer being responsible for anyone they bring in?
It identifies agents and brokers from damages that could occur during access that's being allowed. It does not identify inspectors.
That's what I'm saying, if it's who's indemnifying their agent and all, and saying, and it's basically putting it back on the buyer, right? So if the buyer is inviting all these other people over there, isn't that where this is going?
Yeah, it should go back to the buyer, but.
But what's gonna end up happening is who granted access to those people to the property.
I'm not arguing with you, I'm
that's
just
where it's
saying,
gonna end up coming
yeah,
back.
does the Trek real estate form need to be tweaked a little bit?
All right. Okay, so we're gonna move on to 11, which is a request for future meeting agenda items. Obviously defining the client, move on that one. And then we're gonna do the review of the 535-211 based on our motion. And any other suggestions from committee members?
I don't know.
No? I think that the 535-211 is gonna take a while.
Yeah, and I think, just to be clear, and correct me if I'm wrong, Kristen, it's not just the rule, it's the whole, it's statute, it's a
Right,
statutory
right, I'm sorry,
fix.
I
Yeah.
was just.
Yeah.
Shorthanded.
Yeah.
Sure.
That's about how I wrote it too, but yes, based on the motion that we made. All right, so discussion of future meeting agenda.
We already have a meeting scheduled. Is that what it is? We have a meeting, because you need to elect your officers in February.
Oh, that's right.
So that's the major thing that's going on in that meeting. In addition, anyone who comes to that meeting gets CE credit for the length of the meeting, up to 2 hours. So,
That's the 26th of February.
I believe so. It's a Monday, yeah. But so right now, the only reason you're meeting is to discuss your election of officers, but you put other things on the agenda, obviously, to do that.
Or should we wait till, well, I thought we had like sunset starts in April?
In April.
It does. One possible way to, further the discussion on these items, in addition to just having more committee meetings, is Tony mentioned the strategic planning tour that the commission will undertake. We do that in March, generally late February to March. The schedule and the locations will be available, we hope, in early February. And, so, like we said, we invite y'all to come and participate. We'll invite, inspector license holders to come and participate. And then, another opportunity would be, possibly to work with some of the inspector associations and attend their meetings and explain, what the issues are and all of the different variables that we're considering. And, ask for suggestions, ask for input from those groups and from the stakeholders so that you can make an informed decision.
So, we definitely want to have this discussion in February before we start all of that, so that we can have a map. So we'll keep that agenda item on the February along with election of officers. And no public member for the NPD position. No application. And we still do not have a permanently assigned commissioner to our committee.
I suspect that Avis will appoint somebody at their February meeting because they typically appoint new committees and liaisons in February as well.
Oh, okay, so what happened was we just had sort of a lapse because Bill left before.
Well, Bill's term ended and he was not reappointed by the governor, so we have new commission members.
Right.
And so typically in February, like with all of our committees, that's when the commission elects officers and does the committee shuffle.
Nobody's drawn the short straw.
Yeah, that's what I feel like. Is that we're like the redheaded stepchildren that didn't get somebody from commission, but that's obviously going to be worked on, so.
Yes.
All right. I don't see anything on the schedule for subcommittee before the May.
Do any of the subcommittees want to meet?
I think that we could meet an hour before the next one as well, and
Okay.
'cause I think we're gonna still have some input from the community. Excuse me. But I think we're probably gonna end up finally making a decision that if we do move forward on the standards of practice, we'll have to do a workshop. And that's gonna fall right into the same issue on the report, while we workshop related.
Okay. So you want to schedule that for 9 a.m. on the
9 a.m.
26th, and we'll have the meeting at 10 on the 26th. Do you think we'll need to meet?
Not unless Mr. Moore thinks that we don't need it.
What about education?
I don't know of any input right now.
Okay.
May come out of the SOP side.
Okay, so 13 is to adjourn. It is 12:41.
All right, thank you. Thank you, everyone on the phone.